It's setting up your meeting on for Facebook Live. That's.
You click na go live, no? On PAL.
Yes. Am I on it already?
Yeah, you're live now. Thank you.
Okay, thank you. Okay.
Sorry, Dina.
No problem. Okay. Okay, can I start now?
Yeah, sure.
Okay, thank you very much. Okay. Okay, I'm very sorry. There was some technical glitch, so I have to start again. I hope you were able to join me in prayer. So I will start again with Rule 14. Okay, just give me 1 minute, please. Okay, 1 minute. Okay. Okay, so we go with Rule 14. Again, may I request everybody to kindly use the matrix, which we used last time. Okay, so we start. Section 1, clerk to issue summons. Okay, unless the complaint is on its face dismissible under Section 1, Rule 9, the court shall, within 5 calendar days from receipt of the initiatory pleading and proof of payment of the requisite legal fees, direct the clerk of court to issue the corresponding summons to the defendants. Okay, just by way of recall, the principle is jurisdiction over the defendant is acquired either upon valid service of summons or the defendant's voluntary appearance in court. When the defendant does not voluntarily submit to the court's jurisdiction, or where there is no valid service of summons, any judgment of the court which has no jurisdiction over the person of the defendant is null and void. And that's the case of Manotoc versus Court of Appeals, a 2006 case. No summons, if you will notice in Section 1, no summons will issue if the court motu proprio decides to dismiss the complaint on any of the following grounds. Number 1, no jurisdiction over the subject matter, litis pendentia, res judicata, and prescription. And that's pursuant to Section 1 of Rule 9. Okay. Now, the courts now, under the proposed rule, is given a period of 5 days, okay, from receipt of the initiatory pleading with proof of payment of the required docket fees to cause the issuance of the summons. Now, summons, the service of summons is a valid and a vital and indispensable ingredient of due process. As a rule, if defendants have not been validly served, the court acquires no jurisdiction over the person and a judgment rendered against them is null and void. Chu versus Mac Asia. Okay. Now, what happens if the court, okay, if there was improper service of summons, what will be the remedy of the defendant? Please, defendant, do not file a motion to dismiss because it's no longer allowed, okay? What you should do is that ground should be raised as an affirmative defense in the answer, pursuant to Section 12(1), Rule 8 of the 2019 rules, okay? The court shall thereafter resolve motu proprio the said affirmative defense within 30 calendar days from the filing of the answers, basis Section 12B, Rule 8 of 2019 rules. Okay. Now, what happens if the affirmative defense is denied? Okay. Again, pursuant to Section 12, Rule 8, it shall not be subject to a motion for reconsideration, which means you cannot file a motion for reconsideration against the order denying that affirmative defense. Or it cannot even be subject, of course, of petition for certiorari, prohibition, or mandamus. You cannot even appeal that because that's an interlocutory order. So what is the proper remedy now of the defendant? Go to trial. And in the event of an adverse judgment, appeal the judgment and raise the order of denial as one of the assigned errors. And that is pursuant to Section 12D, okay, Rule 8 of the 2019 rules. Okay. Now we go to the contents. Section 2. The summons shall be directed to the defendant, signed by the clerk of court under seal and contain the following. Okay. The name of the court and the name of the parties to the action, and listen to this, and this is you. When authorized by the court upon ex parte motion, an authorization for the plaintiff to serve summons to the defendant. C, a direction that the defendant answer within the time fixed by the rules. And D, a notice that unless defendant so answers, plaintiffs will take judgment by default and may be granted the relief applied for. A copy of the complaint and order for appointment of the guardian ad litem, if any, shall be attached to the original and each copy of the summons. So it is clear from Section 2 that the substantial amendment to Section 2 is in paragraph D. If the court authorizes the plaintiff to serve summons, then the plaintiff may serve summons, but that should be stated in the summons itself. Now, the court may issue authorization upon ex parte motion also for the plaintiff to serve summons via electronic service, which we will discuss later. Now, let's go to Section 3. The summons may be served by the sheriff, his or her deputy, or other proper court officer, and in case of failure of service of summons by them, the court may authorize the plaintiff to serve the summons together with the sheriff. In cases where the summons is to be served outside the judicial region of the court where the case is pending, the plaintiff shall be authorized to cause the service of summons. If the plaintiff is a juridical entity, it shall notify the court in writing the name and its authorized representative therein, attaching a board dress or sex cert thereto, as the case may be, stating that such representative is duly authorized to serve the summons on behalf of the plaintiff. If the plaintiff misrepresents that the defendant was served summons and it is later proved that no summons was served, the case shall be dismissed with prejudice, the proceedings shall be nullified, and the plaintiff shall be meted appropriate sanctions. If summons is returned without being served on any or all the defendants, the court shall order the plaintiff to cause the service of summons by other means available under the rules. Failure to comply with the order shall cause the dismissal of the initiatory complaint without prejudice. Okay. So, Section 3, I think, must likewise be read in conjunction with Section 2. The plaintiff may be authorized to serve the summons in the following cases. Number 1, in cases where there is failure to serve summons by the sheriff, okay, the court may authorize the plaintiff to serve the summons together with the court sheriff. Hindi mag-iisa si plaintiff. Number 2, the court can likewise authorize the plaintiff to serve the summons in cases where the summons is to be served outside the judicial region of the court where the case is pending. Okay. Notice, however, there is nothing in that particular situation that says that the court sheriff should accompany the plaintiff in serving the summons outside, okay, the judicial region of the court. You know, I think only because the sheriff, okay, of that court cannot really, has no authority to go outside the region. So I think pragmatically speaking, the plaintiff should coordinate, okay, with the sheriff of that judicial region, okay, so that when he when he serves the summons to the defendant, at least may kasama siya namang sheriff, hindi siya nag-iisa. Okay? Now, if the plaintiff is a juridical entity, of course, the person who will represent the plaintiff must be armed, okay, with a special power of attorney, director's certificate, or secretary's certificate, okay? Now, if the plaintiff misrepresents, this is to avoid, let's say, abuse, no? Wherein the plaintiff will be authorized by the court to serve. Para naman tiyak, gagawin talaga ni plaintiff yung inatasan sa kanya. If the plaintiff misrepresents the defendant was served summons, what will happen? Number 1, the case will be dismissed with prejudice. Okay, the proceedings will be nullified. And of course, they will be subjected to appropriate sanctions. If summons now is returned unserved, the court shall order the plaintiff to cause the service of summons by other means, such as by what? Publication. Failure to comply with the order of the court shall cause the dismissal of the initiatory pleading, that such as, of course, your initiatory pleading can be the complaint, the third-party complaint, without prejudice. Notice, may order yung court. Okay, the plaintiff was not able to serve the summons, and then the court now will issue an order saying, "O plaintiff, cause the service of summons through other means authorized by the court." And then the plaintiff did not comply. It is clear from Section 3, okay, Section 3, that the complaint will be dismissed but without prejudice. This, I think, is an exception to the rule mentioned under Rule 17, Section 3, that if you fail to obey the order of the court and you become, of course, a disobedient party, then the complaint will be dismissed with prejudice. Pero ito exception sa rule. Kasi very clear from Section 3, even if you did not follow the court order, okay, the complaint will be dismissed, but this time without prejudice. Okay. Validity of summons and issuance of alias summons, Section 4. Okay. Summons will remain valid until duly served. So, walang lifetime, di ba? Okay. Unless it is recalled by the court. In case of loss or destruction of summons, the court may, upon motion, and that is going to be an ex parte motion, can issue an alias summons. So summons will remain valid until it is what? Recalled, destroyed, or lost. Remedy, if you want another summons, you have to ask the court, go to court and ask the court to issue an alias summons. An alias summons is merely a continuation of the original summons. And that is the ruling in the case of Philippine American Life and General Insurance versus Breva. Okay, now, Section 5. Whenever practicable, the summons shall be served by handing a copy thereof to the defendant in person and informing the defendant that he or she is being served, or if he or she refuses to receive and sign for it, by leaving the summons within the view and in the presence of the defendant. Okay. Jurisdiction over a defendant in a civil case is acquired either through service of summons or through voluntary appearance in court and submission of the defendant to the authority of the court. In the absence of service, or when the service of summons upon the person of the defendant is defective, the court acquires no jurisdiction over his person, and judgment rendered against him is null and void. 2018 case of Interlink Movie House versus CA. Now, how do you serve summons? Okay, first, personal service is effected by handing a copy of the summons to the defendant himself in person. Now, if the defendant refuses to receive and sign for it, then tender it. That is equivalent to personal service. Now, there is one case, and this is the case of Sancho, Philippines versus Spouses Mogul. It's a 2009 case. So in this particular case, Sancho actually filed two cases against Spouses Mogul. Okay, one criminal, one civil. Now, in the civil case, the summons could not be served at the residence of Spouses Mogul. Pumupunta si sheriff, hindi dumadating doon. Wala yung Spouses Mogul. Okay. So what happened was Sancho told the sheriff, anyway, sheriff, we're going to have a hearing on this day in our criminal case, and we are very sure that Spouses Mogul will be there. So kindly serve, okay, the summons to the defendants there in court where we're having our criminal case heard. So that's what happened. The sheriff went there, nakita niya ngayon si Spouses Mogul, binigay niya ngayon yung summons and yung copy of the complaint. Now the defendants, what did the defendants do? The defendants now gave the copy of the complaint to their lawyer. Binasa ngayon ng lawyer. Sabi ng lawyer, oh, ang nakalagay naman sa complaint, serve the complaint and the summons, okay, at the residence. Di ba may paragraph doon sa complaint na defendant is of legal age, married, o ganyan, and a resident of blah, blah, blah. Summons addressed to the defendant may be served at the address indicated above. So sabi ng abogado, oh, malinaw na nakalagay dito sa complaint. You have to serve the summons, okay, to the to the residence of the defendant. So hindi tinanggap ni spouses mogul. So anong ginawa ni sheriff? Iniwan. Okay, iniwan. So what happened in that particular case? Was the court able to acquire jurisdiction over the person of the spouses? Okay. According to the Supreme Court, okay, respondent spouses mogul principally argued that Section 6 of Rule 14 cannot be singled out without construing the same with Section 7. They posit that in a civil case, summons must be served upon the defendants personally at the designated place alleged in the complaint. That was the position taken by the lawyer of spouses mogul. And of course, they followed. No? If the defendants refuse to receive and sign the summons, then the process server must tender the same to them by leaving a copy at the residence of the defendants. If the summons cannot be served in person because of the absence of the defendants at the address stated, then the same can be served by leaving copies of the summons at the defendant's residence with some persons of suitable age and discretion residing therein, or by leaving the copies at defendant's office at a regular place of business with some competent person in charge thereof. Now, according to the Supreme Court, regardless, the fact is, nakita na niya si defendant and the sheriff tendered it, okay? Now, that means when the sheriff tendered it, okay, that was now proper service of summons. So, miski saan ka makita, pag nakita ka ng sheriff at ikaw nga yung defendant, pwedeng ibigay sa yan miski saan. Ngayon, kung hindi mo yan tinanggap, tama yung ginawa ni sheriff, tinender niya. So the court was able to acquire jurisdiction over the person of defendant spouses. Okay, now. In section, now we go now to section, we're done with section 5, now we go to section 6, substituted service. If for justifiable causes, the defendant cannot be served personally after at least 3 attempts, on 2 different dates, service may be effected by leaving copies of the summons at the defendant's residence to a person at least 18 years of age and of sufficient discretion residing therein, by leaving copies of summons at the defendant's office or regular place of business with some competent person in charge thereof. A competent person includes but is not limited to one who customarily receives correspondences for the defendant, by leaving copies of the summons if refused entry upon making his or her authority and purpose known with any of the officers of the Homeowners Association or Condominium Corporation or its chief security officer in charge of the community or the building where the defendant may be found. Okay? By sending, okay, just 1 minute please. By sending an electronic mail to the defendant's electronic mail address if allowed by the court. Okay, now let us now talk about section 6 because this section 6 is talagang new. Okay? Now section 6 basically incorporates decisions already of the Supreme Court. Okay? Now, regardless of what type of action, whether it's in personam, in rem, quasi in rem, the preferred mode of service is personal. Now, to avail themselves of substituted service, courts must rely on a detailed enumeration of the sheriff's action and a showing that the defendant cannot be served despite diligent and reasonable efforts. Okay. The sheriff's return, which contains these details, is entitled to a presumption of regularity. And on this basis, the sheriff may allow substituted service. Should the sheriff's return be wanting of these details, substituted service will be irregular if no other evidence of the efforts to serve summons was presented. Failure to serve summons will mean that the court failed to acquire jurisdiction, okay, over the person of the defendant. Okay. Now, and that's the case of De Pedro versus Romasana, 2014 case. Now, for the presumption of regularity to be applied on a sheriff's return, the sheriff's return must contain the following. Number 1, detailed circumstances surrounding the sheriff's attempt to serve the summons on the defendant. 2, the specifics showing impossibility of service within a reasonable time. And now, based on this requirement, okay, then the sheriff's return will not be considered pro forma. That's according to the case of People's General Insurance Corp versus Guansing, a 2018 case. Now, the following requisites must therefore be observed in order that substituted service of summons could be considered valid. And this is pursuant to the case of Manotok, okay, versus Court of Appeals. Okay. Now, the first requirement, okay, impossibility of prompt personal service. Okay. Ano ba yung prompt personal service? How would you? Several attempts means at least 3 tries, preferably on at least 3 different dates. So pwedeng Monday, umaga, hapon. And then Wednesday, umaga. 2 different dates, 3 occasions. Okay. Number 2 requirement, specific details in the return. The sheriff must describe in the return of summons the facts and circumstances surrounding the attempted personal service. Hindi pwedeng nakalagay lang, nasan si defendant yan? Wala po. Okay, bye-bye. Hindi sufficient yon. The efforts made to find the defendant and the reasons behind the failure must be clearly stated in the detail in the return. The date, the time of the attempts on personal service, the inquiries made to locate the defendant, the name of the occupants of the alleged residence or the house of the defendant, and all other acts, though futile, to serve summons on the defendant must be specified in the return. Okay? Just to precisely show the impossibility of prompt service, okay, at saka yung efforts made to find the defendant and the failure of said efforts. Now, third, the return must likewise show the name of the person of suitable age and discretion. Okay? And remember in the case of Johnson versus Dumagas, dapat yung pinag-iwanan mo ng dokumento kung isinerve mo sa bahay, okay, dapat yan is a resident. Therefore, kunwari, nadaan lang na, in the case of Johnson, kapatid, dumaan lang, nangolekta lang kasi ng renta. Doon ibinigay yung summons. Improper yon. Okay? Because the requirement is the person to whom the summons will be given, okay, in cases of substituted service of summons, and you serve it in the house, must be of suitable age, discretion, and a resident therein. Okay. Now, paano kung sa office? Okay. Kung kunwari binigay sa office. Let's first recall the ruling in the case of Sandoval versus HRET. Of course, the same thing, no? Kung ano yung mga attempts at saka ganyan. Pero pag sa office, dapat ibibigay mo sa isang taong competent person in charge. And what do you mean by competent person in charge? Now, in the case of Sandoval versus HRET, which is a 2002 case, to be a competent person, the person to receive someone means that he should be duly qualified and must have the following: sufficient capacity, ability, or authority. There should be a relation of confidence between the person who received the summons and the defendant. Okay. Ang nangyari kasi dito sa Sandoval versus HRET, isang utility man ang pinagbigyan. So sabi ng Supreme Court, improper yung service na yan kasi yung utility man, hindi naman, unang-una, hindi naman talaga siya employee dun sa office ni Congressman Sandoval. Tapos, well, yun nga, cannot be considered a person of competent authority, he cannot be considered a competent person because he does not have a relation of confidence with Congressman Sandoval. Okay. Now, Section 7. Service upon entity without juridical personality. Okay. When persons associated in an entity without juridical personality are sued under the name by which they are generally or commonly known, service may be effected upon all defendants by serving upon any one of them or upon the person in charge of the office or place of business maintained in such name, but such service shall not bind individually any person whose connection with the entity has upon due notice, okay, been severed before the action was filed. Ito, hindi ito na bago. Remember, only persons who are natural, juridical, and those persons authorized by law can sue. But even if you are not an organized, okay, or an incorporated entity, but you represented yourself to be an incorporated entity, you can be sued. At kanino isuserve ang summons pag yun, if you're an entity without a juridical personality, ibibigay, summons may be effected. Okay, summons may be effected, okay? May be effected upon all the defendants by serving upon any one of them or upon the person in charge of the office or place of business maintained in such name. Okay. Paano kung ang dinimanda natin is single proprietorship? Aling Nenes Carinderia. Okay? Kanino isi-serve? Siyempre si Aling Nenes Carinderia, pag single proprietorship yan, does not possess a juridical personality separate and distinct from the owner. Okay. The law does not vest a separate legal entity on sole proprietorship or empower it to file or defend an action in court. Remember, only natural, juridical persons or entities authorized by law may be parties to a civil action. Kaya sa kaso ni Ejercito versus M.R. Vargas Court, 2008 case, if it's a single proprietorship, kanina isa-serve ang summons dun sa may-ari. Okay? Dun sa proprietor. Okay. Section 8. When the defendant is a prisoner confined in a jail or institution, service shall be effected by him or her by the officer having the management of such jail or institution who is deemed as the special sheriff for that purpose. Okay. The jail warden shall file a return within 5 calendar days from service of summons to the defendant. It is not the court sheriff that will hand over the summons and the complaint to the inmate defendant. It will be the jail warden. Okay? Palagay nyo ba magkakaroon ng substituted service dyan kung hindi mahanap si defendant? Siyempre hindi, kasi ibig sabihin nun nakatakas si defendant, di ba? Kaya personal service yan. Now, if si jail warden ang nagbigay kay defendant ng summons at saka ng complaint, then it is the jail warden who will execute, okay, the sheriff's return. Okay, is that clear? Okay. Now we go to section 9. Service may be made through methods which are consistent with established international conventions to which the Philippines is a party. Okay. Now, ang importante lang dyan sa convention na yan, dapat signatory ang Philippines. Okay. Now, section 10, service upon minors and incompetents. Okay. Section 10, let me just summarize it. Service must be made on the minor and his parent or legal guardian. You just still have to serve it to the minor and then the parent. Insane or incompetent, if they're sued, you serve it on the insane or incompetent and his guardian ad litem. Paano kung wala siyang guardian ad litem? Okay. The plaintiff need not institute a separate action for the appointment of a guardian ad litem. The plaintiff can secure the appointment in the said case. Okay. Now, section 11. When spouses are sued jointly, service of summons should be made to each spouse individually. I think this is very correct. Okay, very correct. The sheriff cannot, on the first attempt to serve the summons to the wife, just leave it to the husband. Husband and wife, dinimanda, first attempt pa lang ni sheriff, binigay niya yung summons sa asawa na lalaki kay husband, and then kay wife, iniwan niya kaagad kay husband. That cannot be. That would be improper substituted service of summons. Dapat is-serve din niya personally dun sa wife. It is only in the event that, there's failure to serve personally that you can effect substituted service of summons. Okay. Now, in the case of, section 12, service upon domestic private juridical entity. Ito malaki rin tong pagbabago. Okay? Now, when the defendant is a corporation, can you just give me 1 minute to check if whether our whether I'm coming in clearly, because I really do not have any feedback. If you can hear me, I cannot. So let me just check with Dean Al, okay? Yes, are we okay? Okay, because I am not sure whether I am coming in clearly to you guys. Baka mamaya usap lang ako ng usap, hindi niyo pala ako naririnig. So let me just double check with Dean, okay? Okay. Okay. Now, Section 12. When the defendant is a corporation, partnership, or association organized under the laws of the Philippines with a juridical personality, service may be made on the president, managing partner, okay, managing partner, general manager, corporate secretary, treasurer, or in-house counsel of the corporation, wherever they may be found, or in their absence or unavailability, okay, under secretaries. If such service cannot be made upon any of the foregoing persons, it shall be made upon the person who customarily receives the correspondence for the defendant at its principal office. Okay. In case the domestic juridical entity is under receivership or liquidation, service of the summons shall be made on the receiver or liquidator as the case may be. Should there be a refusal on the part of the persons above mentioned to serve summons despite at least 3 attempts on 2 different dates, service may be made electronically if allowed by the court as provided under section 6. Okay, let me now discuss this. Okay, the amended provision, section 12, no longer restricts and limits the service of summons to domestic private juridical entities to the president, managing partner, general manager, corporate secretary, treasurer, or in-house counsel. So therefore, the oft-repeated ruling no longer applies. Diba? May ruling kasi noon ang court as held in the case of Green Star Inc., Express Inc. versus Nissan Universal Robina Corp. Ito hindi na nag-a-apply. That the rule now states general manager instead of manager, corporate secretary instead of merely secretary, and treasurer instead of cashier. It has now become restricted, limited, and exclusive only to persons enumerated in the aforementioned provision. It is exclusive. Hindi na yan nag-a-apply. Why? Because aside from those officers mentioned in the first paragraph, sabi ng rule, okay, in their absence or unavailability of the foregoing corporate officers, kung hindi daw, wala daw, unavailable si president, si managing partner, general manager, corporate secretary, treasurer on in-house, okay, you can serve it on their respective secretaries. Okay. Pero notice, okay, wala namang sinabi sa batas, okay, that the service to the secretaries is subject to the requirement that the summons was attempted to be served at least 3 attempts on 2 different occasions. Walang sinabing ganon. Okay? So, in my personal opinion, okay, pag pumunta ka sa presidente, let's say Monday, wala. Okay? Wala rin yung managing partner, wala rin si general manager or si corporate secretary. Sa susunod magbalik mo, pag wala, pwede mo nang, at wala pa rin, pwede mo nang iwanan sa sekretarya. Pangalawa, dapat ba lahat i-serve mo muna doon sa president, managing partner, general manager, corporate secretary, treasurer, or in-house counsel? Walang sinabing ganong requirement. Ang sinabi lang, in the absence or unavailability of the foregoing corporate officers, summons can be served on their secretaries. Okay. Third point. If such service cannot be made on those corporate officers, okay, and cannot be served on their secretaries, pati yung secretaries nila unavailable. Okay. The summons can be served upon persons who customarily receives the correspondence for the defendant at its principal office, yung receiving clerk. Again, walang requirement na sinasaad ng batas that service to the person who customarily receives those documents is subject to the requirement that there should be first that the summons was attempted to be served at least 3 times, okay, 3 attempts on 2 different dates. Wala ring sinabi. So kung hindi mo ma-serve sa corporate officers, sa secretariats, kung hindi mo ma-serve sa secretariats kasi unavailable sila, sinong pupuntahan mo? Yung custodian who customarily receives the correspondence for the defendant at its principal office. Okay? At its principal office. Hindi dun sa kunwari, sa branch. Okay? Hindi pwede sa branch. Dun sa principal office. Now, in case a domestic corporation is under receivership or liquidation, okay, kanino mo isuserve ang summons? Sa liquidator o sa rehabilitation receiver. Okay? At mas tama nga naman yon. Okay, now. So, service of summons, binabanggit din dito that service of summons through electronic means can be resorted to but subject to the following conditions. Okay? Service of summons through electronic means can be resorted to when the summons to the following persons could not be served at least 3 attempts on 2 different dates to the following person. Yan yung may 3 attempts on 2 different dates. Yan ngayon yung may requirement. If you cannot serve it on 3 attempts on 2 different dates to the president, managing partner, general manager, corporate secretary, treasurer, or in-house, the respective secretaries, or the person customarily authorized to receive the documents or kung under receivership sa receiver or under liquidation sa liquidator. Okay? Kanino mo nga, you just have to go to court and ask the court to allow you to serve summons by electronic means. Okay? As provided, okay, under Section 6. Is that clear? Okay. If there is one provision na favorite ko, okay, merong, miski sa procedure, may favorite akong provision. Itong Section 13. Okay. Bakit ko siya favorite? Section 13 is new, very short. When the summons is improperly served and a lawyer makes a special appearance on behalf of the defendant to, among others, question the validity of service of summons, the counsel shall be deputized by the court to serve summons on his or her client. Anong ibig sabihin? Okay. Kunwari nakareceive ako, kunwari ako yung lawyer ng defendant. And let's assume that substituted service of summons, not in accordance with the rule, not in accordance with Manoto. First time lang, sinerve na by substituted means. E dun sa complaint, my prayer for, let's say, TRO. You know, pag may prayer ng TRO, ibig sabihin, or a writ of preliminary injunction, may a-appear ka na kaagad sa korte, hindi pa natatapos yung period to file an answer. Uma-appear ka na sa korte kasi pag-aawayan nyo na yung TRO eh. Okay. Siyempre, pag umappear ka ngayon sa TRO, sasabihin mo na immediately pa lang para sasabihin hindi ma-consider as voluntary submission to the court's jurisdiction, you will say, I'm entering my appearance here as and by way of a special appearance without prejudice to the right of the defendant to question the impropriety of the service of summons. Okay, sinasabi mo, kasi improper yung service of summons. So I'm just appearing here because of the TRO hearing, but this is without, okay, without me submitting to the jurisdiction of the court and waiving the impropriety of service of summons. Di sinabi mo yon. Anong gagawin ngayon ng judge? Pursuant to Section 13.7, ganon, your special appearance. O sige, I'm now deputizing you to serve the summons to your client. And of course, as an officer of the court, I have no choice but to follow the court. And I will now be the one who was deputized to serve the summons to my client. Is that clear? Okay, that is Section 13. Okay. Now, Section 14. Okay, notice, nung binasa natin 1 to 13, depende pa paano i-serve yung summons, depende kung anong klase, okay, yung defendant. Sabi ko nga nung last Monday, you just have to classify, okay, natural, juridical, domestic, now we go to foreign, okay. Service upon foreign private juridical entities. When the defendant is a foreign private juridical entity, which is transacted or is doing business in the Philippines as defined by law, service may be made on its resident agent designated in accordance with law for that purpose, or if there be no such agent on the government official designated by law to that effect, or any of its officers, agents, directors of trustees within the Philippines. Okay. If the foreign private juridical entity is not registered in the Philippines or has no resident agent but has transacted or is doing business in the Philippines as defined by law, such service may, with leave of court, be effected outside of the Philippines through any of the following means: by personal service, course through the appropriate court in the foreign country with the assistance of the DFA, by publication once in a newspaper of general circulation in the country where the defendant may be found, and by serving a copy of summons and the court order by registered mail at least at the last known address of the defendant, by facsimile, by electronic means with the prescribed proof of service, or by such other means as the court in its discretion may direct. Okay. Now, notice that in section 14, service of summons, okay, to foreign private juridical entities is served in different ways depending on where is the foreign private juridical entity. Okay. If the foreign private juridical entity has transacted or is doing business in the Philippines, okay, as defined by law, okay, you can serve it on the resident agent. Lalo na kung yan ay rehistrado, has a permit to do or license to do business in the Philippines. May resident agent yan. I-serve nyo muna sa resident agent. Ngayon, kung walang resident agent, kunwari namatay si resident agent, hindi pa napalitan. So wala siyang resident agent. But the corporation is doing business in the Philippines, kanino mo ngayon isa-serve yung summons? The government official designated by law to receive summons if the corporation does not have a resident agent. Okay. Or, pwede mo rin niyang iserve sa officers, agents, directors, or trustees who are in the Philippines. Okay. Now, on the other hand, if that foreign private juridical entity is not registered in the Philippines or has no resident agent but has transacted or is doing business in the Philippines, okay, such service may, with leave of court, okay, be effected outside the Philippines. Basta lumabas ka ng Pilipinas, with leave of court yan. And paano isa-serve? Okay, number one, personal service, but you have to course it through the DFA. Okay, number two, publication once in a newspaper of general circulation in the country where the defendant may be found, and by serving a copy of the summons and the court order by registered mail at the last known address of the defendant. Pangatlo, you can serve summons to this type of foreign private juridical entity through facsimile machine or by electronic means with the prescribed proof, or by such other means as the court in its discretion may direct. Okay. Please take note that for the purpose of acquiring jurisdiction by way of summons on a defendant that is a foreign corporation, there is no need to prove that there's no need to prove first the fact that the defendant is doing business in the Philippines. The plaintiff only has to allege that in the complaint, okay? And that's it. That is the only requirement, okay, to determine whether this provision will apply. Avonfit Insurance PLC versus CA. Now, service upon public corporation. Let me now summarize it. If the defendant public corporation is the Republic of the Philippines, kanino isa-serve ang summons? Solicitor General. If the defendant public corporation is the province, kanino isa-serve? Sa governor. If the defendant, let's say, is the city, kanino isa-serve yung summons? The mayor. Kung sa municipality ang kalaban mo, kanino mo isa-serve yung summons? Sa mayor. E paano kung ang barangay ang kalaban? Hindi sa barangay captain, sa mayor. Kasi ano naman yun a component naman ng barangay, ng city, a component ang barangay. So the executive officer still will be the mayor. Okay. Now, Section 16, okay? Service upon defendant whose identity or whereabouts are unknown. Okay. In any action where the defendant, okay, in any action where the defendant, okay, is designated as an unknown owner or the like, or whenever his or her whereabouts are unknown and cannot be ascertained by diligent inquiry, okay, within 90 calendar days from the commencement of the action, okay, service may by leave of court be effected upon him or her by publication in a newspaper of general circulation, okay, and in such places and for such time as the court may order. Can you just please give me 1 minute, please, just to double check, okay, if the one who's assisting me in the technical aspect of this is, okay, okay, okay. In such places and for such time as the court may order, okay. Dito sa Section 16, may isang magandang kaso na dinicide yung Supreme Court, okay. Now, Santos versus PNOC, GR number 170943, September 23, 2008. Ano bang nangyari dyan sa kaso ni Santos versus PNOC? Okay, PNOC Exploration filed a complaint for sum of money against Santos Jr. before the Regional Trial Court of Pasig, okay? For collection of sum of money representing Santos's unpaid balance of the car loan advanced to him by PNOC when he was still a member of its board of directors. Okay. Now, personal service of summons could not be effected because Santos could not be located in his last known address, despite earnest efforts to do so. So what did PNOC do? Filed a motion in court and requested the court to allow it to serve the summons by publication. At ganun nga ang nangyari. Granted. Okay. Siyempre, nagkaroon ng judgment by default against Santos. Okay. Ngayon, question ngayon ni Santos pagdating doon sa CA that the proceedings and the judgment should be considered null and void. Why? Because this is an action in personam. And the submission of Santos before the Supreme Court was, dahil action in personam to, then the court can validly acquire jurisdiction over the person of the defendant only through personal service of summons or substituted service, hindi through publication. Tama ba si Santos? Did the court acquire jurisdiction over Santos? Supreme Court said yes. Okay. Petitioner invokes the distinction between an action in rem, okay, an action in rem and an action in personam, and claims that substituted service may be availed of, okay, may be availed of. Can you just give me 1 minute? There's just one concern now, just one concern. 1 minute, please. Okay, I'm so sorry for that. I'm so sorry. Okay, let me now continue. I'm so sorry. Okay. Now, going back to the case of Santos versus PNOC, petitioner invokes the distinction, okay, between an action in rem and an action in personam, okay, and claims that substituted service may be availed of only in actions in rem, okay. Petitioner is wrong according to the Supreme Court. The in rem in personam distinction was significant under the rules prior to the 1997 rules because it was silent as to the kind of action to which the rule was applicable. Because of this silence, the court limited the application of the old rule to rem actions only. This has been changed according to the Supreme Court. The present rule expressly states that it applies in any action where the defendant is designated as an unknown owner or the like, or whenever his whereabouts are unknown and cannot be ascertained by diligent inquiry, Thus, it now applies to any action, whether in personam, in rem, or quasi in rem. Notice that the rules, however, do not require the affidavit of complementary service be executed by the clerk of court. While the trial court ordinarily does the mailing of copies of its orders and processes, the duty to make the complementary service by registered mail is imposed on the party who resorts to service by publication. Moreover, even assuming that the service of summons was defective, the trial court acquired jurisdiction of the person of the petitioner, Santos, because of his voluntary appearance in the court. Okay, now this case of PNOC versus Santos is very important, especially in relation to Section 16. Because in the phrase, no, in any action, kahit nga daw yan in rem, quasi in rem, or in personam, basta ang defendant's identity is unknown, his whereabouts are unknown, you can serve it summons through publication pursuant to Section 16. Okay, now we go to Section 17. Okay. In Section 17, extraterritorial service, when the defendant does not reside and is not found in the Philippines. Wala dito si defendant dahil hindi siya dito nakatira at hindi dito nakikita si defendant sa Pilipinas. And the action affects the personal status of the plaintiff or relates to or the subject of which is property within the Philippines in which the defendant has or claims a real or interest, actual or contingent, on in which the relief demanded consists wholly or in part in excluding the defendant from any interest therein or the property of the defendant has been attached within the Philippines. Service may by leave of court be effected out of the Philippines by personal service or as provided for international conventions in which the Philippines is a party, or by general circulation in such places and for such time as the court may order, in which case a copy of the summons order of the court shall be sent by registered mail to the last known address of the defendant, or in any other manner the court may deem sufficient. Any order granting such leave shall specify a reasonable time which shall not be less than 60 calendar days after notice within which the defendant must answer. Ito yung tinatawag nating extraterritorial service. When is extraterritorial service proper? It is proper when the defendant does not reside in the Philippines and is not found in the Philippines. And the case is either one of the four. One, it affects the personal status of the plaintiff. Okay, petition for annulment of marriage. Number two, relates to or the subject of which is property within the Philippines in which the defendant has or claims a lien or interest actual or contingent. Number three, it is the relief in which the relief demanded consists wholly or in part in excluding the defendant from any interest therein. C and D, or the property of the defendant has been attached within the Philippines. Okay. Para hindi natin makakalimutan, you know, the common denominator actually of B, C, and D, the last three, it's about a property of which the defendant has an interest. And then the first one is action affects the personal status of the plaintiff. But this one will only apply, as I said, if the defendant does not reside in the Philippines and is not found in the Philippines. Now, if those concur, okay, in any of those instances, the service of summons may by leave of court. This time you have to ask the court's permission to effect service of summons either through personal service, okay. Number two, as provided for in international conventions to which the Philippines is a party. Three, by publication in a newspaper of general circulation in such places and for such time as the court may order, in which case a copy of the summons and order of the court shall be sent by registered mail to the last known address of the defendant, or in any other manner the court may deem sufficient. Period of time to file an answer, 60 calendar days after notice within which the defendant must answer. Okay. May isa akong kaso na alala. sinabi lang na court publish, no? Pero walang registered mail na pinadala. Okay? Valid ba daw yung service? Sabi ng Supreme Court, yes. Kasi it will fall under the court in any other manner the court may deem sufficient. Okay. Now, Section 18. Okay. It's very short, so we read it first. Okay. Section 18, residents temporarily outside of the Philippines. Okay. Now, when any action is commenced against a defendant who ordinarily resides within the Philippines, but who is temporarily out of it, service may, by leave of court, be also effected out of the Philippines under the preceding section. Ano ba yung residence? What do we mean by residence? That is the place where the person named in the summons is living at the time when the service is made, even though he may be temporarily out of the country at the time. Okay? And that is the case of Montefalcon versus Vasquez. Okay. Maganda yung kaso niya Montefalcon. Yung husband dyan is seafarer. Okay? Dito talaga siya nakatira sa Pilipinas, pero nung panahon yun, tinawag siya para bumalik magtrabaho ulit sa barko. So nakatira talaga siya dito, tinawag siya, bumalik ngayon siya sa barko. So wala siya sa Pilipinas. And then the wife filed a petition for declaration of nullity of marriage. Pagkatapos nun, yung sheriff sinerve dun sa substituted service. Okay, iniwan dun sa isang kamag-anak kung saan siya talagang nakatira. So the issue there is, did the court acquire jurisdiction over the person of the husband when at the time of the service of the summons, wala na yung husband, nasa barko na? Sabi ng Supreme Court, yes. Okay. Why? Okay. If you read Section 16, okay, of Rule 14, which is the current rule, no, which is actually Section 18 now in the proposed 2019 rules. If you read it, okay, the section uses the words may and also. When any action is commenced against a defendant ordinarily resides within the Philippines, but who is temporarily out of service may, by leave of court, be also effected. Yung gamit na word na may and also, therefore, is not mandatory. Okay, yun daw sinasabi sa Supreme Court. Hindi mandatory na by publication lamang. Other methods of service of summons allowed under the rules may also be available by the serving officer on the defendant seaman. So ideally, the seaman must be personally served summons, but was personal service of summons practicable? Conversely, was substituted service of summons justified? Obviously, personal service of summons was not practicable because at the time, the defendant was temporarily outside of the Philippines already. To proceed with personal service on summons on the defendant seaman who went on overseas contract work would not only be impracticable and futile, it will also be absurd. Okay. Now, in this case, substituted service, okay, was valid and justified because previous attempts were made by the sheriffs to serve the summons but to no avail. Diligent efforts were evidently exerted in the conduct of the concerned sheriffs in the performance of their official duty. Also, the person who received the alias summons was of suitable age and discretion and a resident in the seaman's dwelling. Okay. Now, hindi ibig sabihin basta wala yung defendant, publication lang ang means. No, because precisely when you talk about Section 18 under the proposed rule, it means this is in addition to personal and substituted. Why? Because the defendant who is a temporary resident in the Philippines, who is a resident in the Philippines, is temporarily outside of the Philippines. Kaya makikita nyo yung distinction ng 17 and 18. Dito sa 17, yung extraterritorial service, yung defendant does not reside in the Philippines and is not found in the Philippines. Then you do extraterritorial service of summons. Okay. But if the defendant is a resident of the Philippines but is temporarily outside of the Philippines, then you resort to Section 18. That's the distinction between the two. Okay. Now, we go Section 19. Any application to the court under this rule for leave to effect service in any manner for which leave of court is necessary shall be made by motion in writing, supported by an affidavit of the plaintiff of some person on his behalf setting forth the grounds for the application. So when you file a motion for leave of court to effect service of summons through publication, please do not forget your affidavit. Kailangan may magpapatunay, okay? Bakit dapat summons by publication ang pag-serve ng summons, okay? So when are the following instances where service of publication may be authorized with prior leave? Section 14, service upon foreign juridical entities not registered in the Philippines or has no resident agent but has transacted or is doing business in the Philippines. Number 2, Section 16, service upon defendant whose identity or whereabouts are unknown. Section 17, extraterritorial service. At Section 18, residence temporarily outside the Philippines. Okay. Now, Section 20, within 30 calendar days from the issuance of the summons by the clerk of court and receipt thereof, the sheriff or process server or person authorized by the court shall complete its service. Within 5 calendar days from service of the summons, the server shall file with the court and serve a copy of the return to the plaintiff's counsel personally by registered mail or by electronic means authorized by the court. Should substituted service have been effected, the return should state the following. Kaya makikita nyo kaagad kung improper yung service ng substituted service of summons. Kasi now, dapat ito ang nakalagay sa sheriff's return bag at dapat doon mo makita yung basis to effect service of summons through substituted means. Anong dapat nakalagay? Impossibility of prompt personal service within a period of 30 calendar days from issue and receipt of summons. The date and time of 3 attempts on at least 2 different dates to cause personal service and the details of the inquiries made to locate the defendant residing thereat. 3, the name of the persons at least 18 years of age and of sufficient discretion residing thereat, name of the competent person in charge of the defendant's office or regular place of business, or name of the officer of the association, okay, or condominium corporation or its chief security officer in charge of the community or building where the defendant may be found, which incidentally, again, is based on a Supreme Court case, di ba? Ayaw papasukin sa isang posh village, okay? Ayaw papasukin, nalaman sheriff, sabi nung security court, ay, sandali ho, tatawagan ho namin yung si Mr. So-and-so. Tapos sabi ni Mr., ay, sorry, hindi ho kayo pwedeng pumasok. Okay? Kasi sabi ng may-ari, hindi kayo papapasukin. So anong gagawin ni sheriff? Matapos niyang sabihin sa security guard na isi-serve niya yung summon kay Mr. So-and-so. Ang gagawin ni sheriff, hahanapin niya na ngayon yung either the officers of the homeowners association or kung sa condominium naman yung officers ng condominium association or yung chief ng security guard, doon niya ibigay yung summons. Kasi ayaw siyang papasukin Okay. Ngayon, pag lahat siya nakalagay, okay, doon sa sheriff's return, then the presumption of regularity will arise. Ngayon, kung incomplete yan, walang presumption of regularity dyan, di ba? Okay. Now, proof of service. The proof of service of summons shall be made in writing by the server and shall set forth the manner, place, and date of service, shall specify any papers which have been served with the process, and the name of the person who received the same, and shall be sworn to when made by a person other than a sheriff of his or her deputy. If summons was served by electronic mail, a printout of said email with a copy of the summons as served and the affidavit of the person mailing shall constitute as proof of service. Section 22. If the service has been made by publication, paano mo mapuprove na it was served by publication? Get the affidavit of the publisher, the editor, business, or advertising manager. Okay, to which the affidavit, a copy of the publication attached, and by an affidavit showing the deposit of a copy of the summons and order for publication in the post office, postage prepaid, directed to the defendant by registered mail to his or her last known address. In Section 23, okay, the defendant's voluntary appearance in the action shall be equivalent to service of summons. The inclusion in a motion to dismiss of other grounds aside from lack of jurisdiction over the person of the defendant shall be deemed a voluntary appearance. Okay. Please remember, okay, that once you ask for affirmative relief, you are deemed to have submitted to the jurisdiction of the court. And that's the case of Interlink Movie House versus CA. What are the examples of, you asking affirmative relief? Motion for extension of time to file answer, motion for reconsideration, motion to set aside order of default, motion to lift order of default, or a motion for, let's say, motion for recon, motion for new trial, voluntary and submission to the trial court's jurisdiction. Okay. And always remember, and this I said is very important, a motion, that the court failed to acquire jurisdiction over the person of the defendant cannot be a ground to sustain to support rather a motion to dismiss. The rules now require that you have to what? Raise it by way of affirmative defense. Is that clear? Well, I hope it's clear. Okay. Now, okay, section 15. Okay. Okay, section 15. Motion. Okay. Unang-una sa motion, kalimutan na natin yung sections 4 and 5. Okay. Anong ibig ko sabihin kalimutan natin yung sections 4 and 5? Sections 4 and 5, which require, the movant to provide a notice of hearing to state when, the day, and the time when the motion will be heard, hindi na yan, wala na yan. Okay? Hindi na yan requirement in sections 4 and 5. Okay. Okay, so yun, no? So ano muna ba yung motion? It's an application for relief other than by a pleading. Okay. Look at your section 2. Malaking pagbabago kasi itong motions in section 2. All motions shall be in writing except those made in open court or in the course of a hearing or trial. A motion made in open court or in the course of a hearing or trial should immediately be resolved in open court after the adverse party is given the opportunity to argue his or her opposition thereto. When a motion is based on facts not appearing on record, the court may hear the matter on affidavits or depositions presented by the respective parties, but the court may direct the matter be heard wholly or partly on oral testimony or depositions. Okay. So there are now two kinds of motions as recognized by the rules, no? In writing or oral. Okay. Ngayon, if in the course of the trial, sabihin kunwari, Your Honor, may I request for a continuance because of lack of material time. Naghihiring kayo, tapos biglang sabi ng plaintiff, for lack of material time, Your Honor, may I request that the hearing be for a continuance. Bago mag-rule si judge, tatanungin niya yung kabila, anong masasabi mo? And then the court now will make a ruling right then and there. Okay. Now, if a motion, on the other hand, is based on facts that are facts not appearing on the record, the court may require submission of affidavits or depositions. Okay. And the court may require oral testimony or depositions. Okay. Look at your section 4. Non-litigious motions. Motions which the court may act upon without prejudicing the rights of adverse parties are non-litigious. Okay. Dito sa section 4, this is the first time where we have non-litigious motions. Okay. Yan yung amendment. So meron na tayong dalawang klaseng motions, not only as to the form, but as to the substance. As to the substance, we have non-litigious and litigious. What are non-litigious motions? Okay, as ruled in the case of Baganos versus Postanosas. Non-litigious motions are motions which the court may act on without prejudicing the rights of the adverse party. Okay. This motion, okay. And what are the examples according to the court? Yan, nakalista. Motions for the issuance of alias summons. Motions for extension of time to file answer. Motion for postponement. Motion for the issuance of writ of execution. motion for the issuance of alias writ of execution, motion for the issuance of writ of possession, motion for the issuance of an order directing the sheriff to execute the final certificate of sale, and other similar motions. Okay. Before I go to the next paragraph, let me just comment on these motions. Okay. These motions, in the first place, shall not be set for hearing. Ayun yung sunod na paragraph. And shall be resolved by the court within 5 calendar days from receipt of the said non-litigious motion. Okay. Now, as I said, okay, notice as an example ng non-litigious motion, motion for the issuance of an alias summons. Bakit ka hihingi ng alias summons? Na-return yung summons at served, nasira o nawala. So you ask for a motion for the issuance of an alias summons. Motion for extension of time to file answer. This motion for extension to file answer, notice under Section 11, Rule 11, a defendant under meritorious circumstances may only be granted an additional period of not more than 30 calendar days to file an answer. Isang beses lang time, one time, big time extension. A defendant is only allowed to file one motion for extension of time to file an answer. Okay. Anong pangalawa? Motion for postponement. You can file a motion for postponement, but under Section 2, Rule 30, which we will discuss later, of the 2019 rules, okay, the party who caused the postponement is warned and will be warned that the presentation of its evidence must still be terminated on the remaining dates previously agreed upon. Hindi ka porke binigyan ng court o pinayagan ka ni court i-postpone, may additional or may kapalit na date para ibigay sa'yo. Hindi pwedeng i-extend yung period na pinag-usapan. Okay. Motion for the issuance of a writ of execution. Okay. I just would like to comment here for the motion of issuance of writ of execution. I will agree that it might be a non-litigious motion if the writ of execution prayed for is a matter of right. Okay. Remember that once a judgment becomes final, the prevailing party is entitled to the writ of execution as a matter of right, and the issuance thereof is the court's ministerial duty compellable by mandamus. In fact, it has been fittingly said that execution is the fruit and the end of the suit, and is very applicable to the life of the law. That's the case of Mindanao Terminal and Brokerage Service versus CA. But what if the motion is a motion for execution pending appeal? Hindi naman siguradong ano yan. What you call this? Non-litigious. It should be considered as litigious because in the first place, the movant has the duty to show good cause. At saka yung kabila, dapat magbigyan ng opportunity naman na i-contest yun, di ba? Okay. Now, motion for execution of an alias writ of execution. And na-issue na yung writ of execution, na-return lang unserved. So, pwede kang humingi ng alias kung naibalik na. Okay. Okay. Number 2. Motion for issuance of a writ of possession. Okay. My comment on this. A writ of possession is a writ of execution employed to enforce a judgment to recover the possession, okay, of land. Okay. It commands the sheriff to enter the land and give possession of it to the person entitled under the judgment. A writ of possession may be issued in the following instances. In land registration cases under Section 17 of Act 496, in judicial foreclosure, provided that the debtor is in possession of the mortgage realty and no person, not a party to the foreclosure suit, had intervened. In an extrajudicial foreclosure of real estate mortgage under Section 7 of Act 3135. And number 4, in execution sales, okay? And that's the last paragraph of Section 33, Rule 39 of the Rules of Court. And this is based on the case of Spouses Reyes versus Spouses Chum, a 2017 case. Now, after the expiration of the period to redeem and no redemption was made, the purchaser as the confirmed owner has the absolute right to possess the land, and the issuance of the writ of possession becomes a ministerial duty of the court upon proper application and proof of title. Okay. That's the case of Gatuslav versus Yanson. Okay. Pero pagka may ibang tao na nakatira doon at nagpo-possess ng land adverse to the judgment of obligor, okay? Or the owner of the property, di ba? Hindi yan ministerial ang issuance ng writ of possession. Okay. Now, another example of a non-litigious motion will be your motion for issuance of an order directing the sheriff to execute the final certificate of sale and other similar motions. Okay. Now, may I just go back to this example, this one example of non-litigious motion, which is a motion for the issuance of a writ of execution, which is 1, 2, 3, the fourth example. No? Does it mean therefore that, the writ will just issue and will, paano kunwari talagang nabayaran mo na yung utang? Okay? Nabayaran mo na yung utang, pagtatapos noon ay nag-file pa ng motion for issuance of writ of execution si judgment obligee. Okay? Are you not entitled to be heard on the matter? I think, you can still file your comment or your opposition there too. Or, kung ang writ na issue, di mag-file ka ng motion to quash. Oo. Hindi pa rin nawawala yung karapatan mo i-contest, no? Ang ano lang dito is, kung talagang hindi mo nabayaran at talagang final and executory na yung judgment, then the writ of execution will issue as a matter of right. Okay. Okay, so we go now to section, okay, section, wait, just let me, okay, wait, okay, just, okay. So as I said, if it's a non-litigious motion, the judge will not set it for hearing. You will not set it for hearing. The judge will not set it for, the court will not calendar it for hearing. The court will resolve it within 5 days from receipt of the said motion. But remember, any motion you file, you have to furnish the other party a copy of the said motion and then file the original in court. Miski na sabihin mong non-litigious motion yan. Okay, section 6, and this is very important. The notice of hearing on litigious motion discretionary. The court may, in the exercise of its discretion, and if deemed necessary for its resolution, call a hearing on the motion. The notice of hearing shall be addressed to all parties concerned and shall specify the date and time and date of the hearing. And this is the reason why I said earlier, the current practice now where we put notice of hearing, tapos yung address, tapos greetings. Okay, please be advised that the foregoing motion shall be heard on this date, at this time, or at any time convenient to the court's calendar, or for the consideration of the court, something to that, and then you sign. Wala na yun. Pag litigious motion siya, who will set it for hearing? It is the court. And the court may, in the exercise of this discretion, hindi automatic. Pag nakita lang na court, dapat i-hear to in its discretion. And if it deems it necessary for its resolution, will set the hearing on a Friday because your motion day is always, our motion day is always a Friday. And then it will send a notice of hearing addressed to all the parties concerned and shall specify the time and date of the hearing. Kaya, miski na hindi natin isi-set yan, so sa mga nagpo-practice, wag nating punuin yung ating Friday. Kasi pag nag-file tayo ng motion at sinabi ng court, ay gusto ko itong i-hit, isi-set niya yon sa Friday. Okay. Section 7. So wala na yung 3-day notice rule in effect. Wala na rin yun. Okay? Section 7. Proof of service necessary. No written motion shall be acted upon by the court without proof of service thereof, pursuant to Section 5B hereof. Okay? Now, kung ang mangyayari dito is the motion, any motion, whether it's litigious or non-litigious, okay? Motion, whether litigious or non-litigious, you have to serve it to the other party and then file it in court. Section 8, and this is the basis of what I said earlier, except for motions requiring immediate action where the court decides to conduct hearing on litigious motion, the same shall be set on a Friday. Okay. Now, yung omnibus motion, hindi pa rin yan nawawala. Okay? Subject to the provisions of Section 1 of Rule 9, a motion attacking a pleading, order, judgment, or proceeding shall include all objections then available, and all objections not so included shall be deemed waived. Now, the omnibus motion rule embodied in Section 8, Rule 15, in relation to Section 1, Rule 9, demands that all available objections be included in a party's motion. Otherwise, said objection shall be deemed waived. And the only grounds that the court could take cognizance of, even if not pleaded in said motion, are lack of jurisdiction over the subject matter, existence of another action pending between the same parties for the same cause, barred by prior judgment, and statute of limitations. And the basis is Pilipinas Shell versus Romars International Gases Corp. Now, what is the purpose of the omnibus motion rule? It requires the movant to raise all available exceptions in a single opportunity to avoid multiple piecemeal objections. But to apply the statutory norm of omnibus motion rule, the objections must have been available to the party at the time the motion was filed. PH Credit Corp versus CA. Section 10, no substantial change. Section 11, no substantial change. Okay. Now, this is the more important one because this is an innovation. Okay. Okay. Section 12, prohibited motions. The following motion shall not be allowed. Okay? The following motion shall not be allowed. There is now such a thing as prohibited motions. Ang may prohibited motions tayo, prohibited pleadings, nakikita natin yan sa prohibited pleadings, no? Nakikita natin yan sa summary judgment o kaya motion, rule, small claims, prohibited pleadings. At saka rules on summary procedure, prohibited pleadings. Ngayon, may prohibited motions. The following motions shall not be allowed. First, motion to dismiss except on the following grounds: that the court has no jurisdiction over the subject matter of the claim, that there is another action pending between the same parties for the same cause, and that the cause of action is barred by prior judgment or by statute of limitation. Okay. Ano pa? Motion to hear affirmative defenses. Motion for reconsideration of the court's action on affirmative defenses. Motion to suspend proceedings without temporary restraining order or injunction issued by a higher court. Motion for extension of time to file pleadings, affidavits to any other papers except a motion for extension of time to file an answer as provided by Section 11. Motion for postponement intended for delay except if it's based on acts of God, force majeure, or physical inability of the witness to appear and testify. If the motion is granted based on such exceptions, the moving party shall be warned that the presentation of its evidence must be terminated on the dates previously agreed upon. A motion for postponement, whether written or oral, shall at all times be accompanied by the original official receipt from the office of the clerk of court evidencing payment of the postponement fee, Section 21B, Rule 141, to be submitted either at the time of the filing of said motion or not later than the next hearing date. The clerk of court shall not accept the motion unless, okay, may bayan. Okay, now, let me now discuss each and every prohibited motions and relate it with the others. Okay. Okay, prohibited motion. Okay, the first one. The new provision on prohibited motions, okay, stresses the underlying principle of the amendments, that is to make the disposition of every action and proceeding more just, speedy, and inexpensive as to prevent delay and to decongest the court. Okay. General rule, motion to dismiss not allowed except if the motion to dismiss is grounded on this apat na sikat: lack of jurisdiction over the subject matter, litis pendentia, res judicata, and prescription claims or statute of limitations. Now, kindly note under Section 1, Rule 9 of the 2019 rules, the four grounds are grounds that may even cause the dismissal of the complaint motu proprio. Now, kakaiba nga lang itong prescription na ground. Bakit ko sinabing kakaiba yung prescription na ground? If the ground is prescription, okay, you can raise it in a motion to dismiss. Okay? Now, if the issue of prescription, however, or you can, all these grounds you can also raise in by way of affirmative defenses. But if the issue of prescription is one that involves a full-blown trial, okay, the court now may require presentation of evidence. And I think that's the reason why when it comes now, if you raise it by way of affirmative defense, the court may set it for hearing, actually, for clarificatory hearing if the court deems it proper to have a hearing set on that matter. Okay. Laches is not a ground, okay, for a motion to dismiss because laches must be raised as an affirmative defense and not in a motion to dismiss. This is because the elements of laches must be proven positively. Laches is evidentiary in nature, a fact that cannot be established by mere allegations. Said issue must be resolved through presentation of evidence, and that's the case of Sanchez versus Sanchez, a 2013 case. Okay. Okay, now, again, before I leave that issue on motion to dismiss, okay, if you raise this for in an affirmative defense, okay, and the court denies those affirmative defenses based on the for, okay, what will happen, okay, you cannot file a motion for reconsideration against the order denying that affirmative defense. You cannot even make it a subject matter of a petition for certiorari, mandamus, or prohibition. But if you raise this for in a motion to dismiss, okay, there is no rule that bars you from filing a motion for reconsideration if that motion to dismiss is denied. And there is no rule that prohibits that the order denying the motion to dismiss and the order denying the motion for reconsideration be made subject of a Rule 65 petition. Okay. 3. Because of the repeal of Rule 16, okay, because of the repeal of Rule 16, when you file that motion to dismiss grounded on any of the four, and the motion is denied, what is the period of time within which to file an answer? Kasi remember, doon sa Rule 16, sinabi dyan, okay, that you have the remaining period but not less than 5 days within which to file the said answer. But because of the repeal of Rule 16, what will happen? Okay? Then the remaining period should be that the period within which to file an answer should be the remaining period. Okay? Kung nakuha mo yung summons June 1, okay? And then you have 30 days within which to file an answer. Pagkatapos final mo, let's say June 11, okay, 30 minus 11, yun na yung period nyo within which to file an answer. Okay. Now, okay. The second, okay, there is no need for you to file a motion to hear affirmative defenses, okay? It is now prohibited pleading because precisely under Rule 16 of the current rules, okay, you really have to file a motion to hear affirmative defenses, okay? And it will be treated as if a timely motion to dismiss was filed. But here, because you raise it by way of affirmative defenses, independent affirmative defense mo, the court will act on it, you need not file a motion to hear affirmative defenses anymore. Okay? Motion for reconsideration of the court's order or court's action on the affirmative defense, lalo na pag denial, you cannot file a motion for recon. Okay. Now, motion to suspend proceedings. Okay. Tama naman to, you don't file a motion, you don't suspend the proceedings below if, let's say, an interlocutory order was raised via certiorari. Okay? Because unless the higher court issues, let's say, an injunctive relief like a PRO or WPI, the proceedings below will not be abated or suspended. But let us not forget the ruling of the Supreme Court in the case of Eternal Gardens memorial part, which was reiterated in the case of Trajano versus Uniwide Sales. And ano ba yung ruling na yon? That is the principle of judicial courtesy. The principle of judicial courtesy applies only if there is a strong probability that the issues before the higher court would be rendered moot and moribund as a result of the proceedings or continuation of the proceedings in the lower court. That principle will therefore allow the lower court, notwithstanding the non-issuance of a TRO or WPI, to stop out of judicial courtesy. But this is an exception rather than the rule. Okay, now, motion for extension of time. Okay, I just would like to stress that the motion for extension of time to file pleadings, affidavits, or any other court submission, that's the general rule. The only exception is a motion for extension of time to file an answer. And you can only do it once. Okay? You can only do it once. Motion for extension. Okay, but I have a question lang. No? How about judicial affidavits? Sa judicial affidavit rule, AM number 12-8-8SC, okay, nahando sa JA rule, you can ask for an extension of time. Ito dito sa Rule 12, miski yung JA, hindi ka na pwede mag-ask for extension of time. So how will we reconcile the two? Okay, impliedly repealed ba to ng provision ng Rule 12? It would appear. Okay. Motion for postponement. Okay. Motion for postponement intended to delay except if it's based on acts of God, force majeure, or physical inability will not be allowed. Okay. But even if, let's say, it is based on acts of God, physical inability, or force majeure, at grinant yung motion to postpone mo, you must finish the presentation of your evidence based on the schedule as agreed upon during the pre-trial conference, which we will discuss later. Okay. Okay. Now, Section 13. Okay. Subject to the right of appeal, an order granting a motion to dismiss, okay, or an affirmative defense that the cause of action is barred by a prior judgment or by statute of limitations, that the claim or demand set forth in the plaintiff's pleading has been paid, waived, abandoned, or otherwise extinguished, okay, or the claim on which the action is founded is unenforceable under the provisions of the statute of frauds, shall bar the refiling of the same action. If you cannot refile it, then your only remedy is appeal. Okay. Just by way of recall, the difference between a dismissal with prejudice and one with prejudice is that the former, the one with dismissal with prejudice, it bars the refiling of the complaint. Whereas if the dismissal is without prejudice, then the same can be refiled. And that's the case of DBP versus Scarpio. Okay. When the law permits, a dismissal with prejudice is subject to the right of appeal. Okay. Now, as I said, Rule 16, deleted yan. Pero miski na-delete yung Rule 16, yung provisions na yan, na makikita mo sa iba't ibang parte ng 2019 rules, no? And even if it was deleted, ang rules natin, 15, walang 16, 17. There was no renumbering. So 15, 16, parang elevator. 12, 14, walang 13. Okay. Now, 17. Dismissal upon notice by plaintiff was not changed, Section 1. Okay, was not changed. But let me just discuss Section 1. I will not read the provision anymore because the provision under Section 1, Rule 17, was not at all changed. A complaint may be dismissed as a matter of right anytime before the service of an answer or a motion for summary judgment. What marks the loss by the plaintiff of the right to cause the dismissal of the action by mere notice is not the filing of the defendant's answer, okay, with the court, either personal or by mail, but the service on the plaintiff of said answer or of a motion for summary judgment. This is clear from the language of the rule. Okay, so that's one. Okay, number two. Okay. Notwithstanding that the notice of dismissal may be filed as a matter of right, the plaintiff must wait for the confirmatory order of the court. Otherwise, it may be construed as an act of disrespect or discourtesy, since plaintiffs should await the court's action on their notice of withdrawal of the petition. And that's a case of Executive Secretary Burr versus Gordon. The dismissal will no longer be a matter of right if the plaintiff who was once dismissed in a court of competent jurisdiction an action based on or including in the same claim. But in the case of Ching versus Cheng, the provision on the two dismissal rule will not apply if the prior dismissal was done at the instance of the defendant. Dapat yung dismissal na yan both at the instance of the defendant, the plaintiff rather. Okay, section 2. Okay, section 2. Again, the change here is basically, okay, let me just read it because there's a change. Except as provided in the preceding section, a complaint shall not be dismissed at the plaintiff's instance, save upon approval of the court and upon such terms and conditions that the court deems proper. Okay? If a counterclaim has been pleaded by defendant prior to the service upon him or her of the plaintiff's motion for dismissal, the dismissal shall be limited to the complaint. The dismissal shall be without prejudice to the right of the defendant to prosecute his or her counterclaim in a separate action unless within 15 calendar days from notice of the motion, he or she manifests that he or her preference to have or her counterclaim resolved in the same action, unless otherwise specified in the order. A dismissal under the paragraph shall be without prejudice. A class suit shall not be dismissed or compromised without the approval of the court. Okay, let me discuss this section 2. Okay, and this is a very recent case of Bly versus Bana. It's a 2018 case. The second sentence of the provision, okay, yung if a counterclaim has been pleaded by the defendant prior to the service upon him of the plaintiff's motion for dismissal, the rule is that the dismissal shall be limited only to the complaint. Commentaries on the subject elucidate that instead of an action, what will be dismissed is the complaint. So a dismissal of an action is different from a dismissal of the complaint. For this reason, since a complaint and not the action is dismissed, the defendant, in spite of said dismissal, may still prosecute his counterclaim in the same action. So na-dismiss yung complaint, but the defendant can prosecute in the same action his counterclaim, whether the counterclaim is permissive or compulsory. However, as stated in paragraph 2, if the defendant wants to prosecute his counterclaim in the same action, he is required to file a manifestation in court within 15 days from notice of the said motion. Ngayon, kung hindi siya mag-file ng motion, lumagpas yung 15 days, then his counterclaim, okay, his counterclaim may be prosecuted in a separate action, Bly versus Bana. Bakit ganon? Now, as explained by Justice Regulado in his treatise on the matter, under this revised section where the plaintiffs move for the dismissal of the complaint to which a counterclaim has been interposed, the dismissal shall be limited only to the complaint. Such dismissal shall be without prejudice to the right of the defendant to either prosecute his counterclaim in a separate action or to have the same result in the same action. Should he resolve to prosecute it in a different court, okay? Or he does not have to file a manifestation. But if he wants to prosecute it in the same case, file that manifestation and you're given a period of 15 days. Bakit kailangan mong i-file yan within the 15-day period? Because after 15 days na na-dismiss na yung court action, technically the court no longer has any authority to try the case kasi the judgment has already attained finality. So dapat mo yun i-file within the 15-day period. Okay, now, again, the case of Bly versus Bana. Okay. Now, in the case of now the third section, okay, section 3, okay. If for section 3, dismissal due to fault of plaintiff, If for no justifiable cause the plaintiff fails to appear on the date of the presentation of his or her evidence in chief on the complaint, or to prosecute his or her action for an unreasonable length of time, or to comply with these rules or any order of the court, the complaint may be dismissed upon motion of the defendant or upon the defendant's own motion without prejudice to the right of the defendant to prosecute his or her counterclaim in the same action or in a separate action. This dismissal shall have the effect of an adjudication upon the merits unless otherwise declared by the court. Again, by way of recall, lalo na dun sa kumuha na ng civil procedure. If the defendant or if the plaintiff did not appear during defendant's presentation of his evidence, the defendant cannot file a motion, okay, to have the complaint dismissed. Why? Because na-prosecute na siya ng plaintiff. At most, ang magiging effect lang yan if the plaintiff does not appear during the presentation of defendant's evidence, the right of the plaintiff to object to question will all be deemed waived. Okay. Pangalawa, okay, dito sa rule na nagsasabi na, okay, if you fail to comply with the rules or order of the court, complaint will be dismissed with prejudice because you'll be considered a disobedient party. But remember, there are two exceptions to the rule, okay, as we have discussed before. The first exception to the rule is if the court orders you to implead a necessary party, you do not implead a necessary party, ang hindi yan madidismiss yung complaint. Magkakaroon lang yan ng waiver, okay? Waiver, okay? To go against the necessary party. Pangalawa, kung hindi ma-serve yung summons, okay? And then the court orders you to cause the service of summons and through other, in accordance with the means allowed under the rules of court, hindi mo yan ginawa. It will be dismissed, but it will not be with prejudice. Okay. Pangatlo, okay. Pagdating sa Section 3, pareho ng Section 2, you can prosecute in the same action or in a separate action, right? Your counterclaim, whether it's permissive or compulsory. But the difference is, bakit dun sa Section 3 may 15 days you are required to notify the court whether you're going to prosecute it, okay, in the same case or in a separate case. Okay? You're given a period of 15 days para i-notify yung court. But sa Section 3, wala yung 15-day period na yan. Kasi, sino ba ang nag-file ng motion doon sa Section 2? Yung plaintiff. Kaya ikaw, kailangan mo sabihin sa court. Itong Section 3, ikaw ang nag-file ng motion, sabihin mo na sa court kung anong gusto mong gawin doon sa iyong counterclaim. Okay? Whether you want to prosecute it in the same case or in a different case. Section 4 is the same. Okay. Let's just have, okay, a 1-minute break or 2-minute break, okay? Then we go to Rule 18. After Rule 18, mabilis na yan. Very, very fast, no? Kasi wala naman masyadong substantial changes. Mabilis na yan. Section 30 ang malaki. So let's just have a 1-minute break for you to get water, drink, and, you know, exercise a bit. Okay. Okay. Now let's go now to Rule 18. Okay. Just 1 minute. Okay. Rule 18. When conducted, after the last responsive pleading has been served and filed, the branch clerk of court shall issue within 5 calendar days, okay, from filing a notice of pretrial, which shall be set not later than 60 calendar days from the filing of the last responsive pleading. Okay. Now, pretrial, as I said, a pretrial is a procedural device intended, okay, to clarify and limit the basic issues between the parties. It's supposed to pave the way for a less cluttered trial and resolution of the case. It's meant to abbreviate, simplify, and expedite the trial. Therefore, there is a need for strict adherence to the rules, okay? And that's pursuant to the case of Chua versus Spouses Cheng. When section 1, okay, states responsive pleading, okay, when after the last responsive pleading, ano ba yung last responsive pleading? It is not necessarily the answer. Remember, under the rules, it may be the reply. If the complaining party wants, not the complaint, but the defendant, okay, no wait, the complaining party, right, wants to deny the due execution of an actionable document which was attached, okay, and made part of the answer, okay, or if the answer, okay, or if the answer is, let's say, if the reply is based on an actionable document, okay, then it may be a rejoinder if the defendant would like to deny the due execution and authenticity of an actionable document that was attached to the reply. Okay. Issues must be joined before the pretrial can be scheduled. Issues are joined when all the parties have pleaded the respective theories and the terms of the dispute are plain before the court. And that's Rosetta versus Lim. Under Section 1, it is the duty of the court, or clerk of court rather, to schedule the pre-trial conference. Okay. Now, Section 2, the pre-trial is mandatory and shall be terminated promptly. Okay. Now, let me just read this. This one is quite long. Section 2. The pre-trial is mandatory and should be terminated promptly. The court shall consider the possibility of an amicable settlement or of a submission to alternative modes of dispute resolution, the simplification of the issues, the possibility of obtaining stipulations or admissions of facts and of documents to avoid unnecessary proof, the limitation of the number and identification of witnesses and the setting of trial dates, the advisability of preliminary reference to issues to a commissioner, the propriety of rendering judgment on the pleadings or summary judgment or dismissing the action should a valid ground therefore be found to exist. Now, and this is important, the requirement for parties to mark the respective evidence, if not yet marked, in the judicial affidavits of their witnesses. Examine and make comparisons of the adverse parties' evidence vis-a-vis the copies to be marked. Okay. Number 3, manifest for the record stipulations regarding the faithfulness of the reproductions and the genuineness and due execution of the adverse parties' evidence. Reserve evidence not available at the pre-trial but only in the following manner. For testimonial evidence, by giving the name or position and the nature of the testimony of the proposed witnesses. For documentary evidence and other object evidence, by giving a particular description of the evidence. No reservation shall be made if not made in the manner described. Such other matters as may aid in the prompt disposition of the action. Failure without just cause of a party and counsel to appear during the pretrial despite notice shall result in the waiver of objections to the faithfulness of the reproductions marked or the genuineness and execution. The failure without just cause of a party and or counsel to bring the evidence required shall be deemed a waiver of the presentation of such evidence. The branch clerk of court shall prepare the minutes of the pretrial which shall have the following format, which is the format is attached to the rules. Okay. Let me just discuss this, especially to those who are already practicing. Okay. Okay. Section 2 is really very important. Okay. Why? Okay. Now, okay, for the students, we all know that admissions made in a stipulation of facts at pre-trial dispenses now the presentation of evidence because they are considered as judicial admissions. And judicial admissions require no proof, okay? Eastern Shipping Lines. Now, the veracity of judicial admissions requires no further proof and may be controverted only upon a clear showing that no such admission was made or, okay, or no such admission was made or it was made through palpable mistake. So admissions of parties during pretrial as embodied in the pretrial order are binding and conclusive upon the person making them. And that's a case of Cuenco versus Talisay Tourist Sports Complex. Okay. Now, di babalikan natin yung diniscuss natin last time. Pag nag-file tayo ng complaint, pag nag-file tayo ng answer, dapat na handun na kasama as a rule yung judicial affidavits, documentary evidence mo, and even the object evidence. Dapat nakalakip yan. Okay. Ngayon, pagka ngayon tayo pupunta during pre-trial, anong mangyayari? Nire-refer tayo for preliminary conference. Doon sa preliminary conference, magpapakitaan na kayo ng mga dokumento for purposes of marking and comparing. Okay. You show to the other party the photocopy and the original of the document, and then you ask the other party to compare it so that you can have the photocopy marked in evidence. Okay. Now, just by way of reminder, there is a significant distinction between identification of documentary evidence and formal offer of evidence. When you speak of identification of documentary evidence, that is done in the course of the pre-trial, that is done during the trial, and is accompanied by marking of evidence as an exhibit. While, okay, formal offer of evidence is done only when the party is about to rest its case. The mere fact that a particular document is identified and marked as an exhibit does not mean that it has already been offered as part of the evidence. It must be emphasized that any evidence which a party desires to submit for consideration of the court must be formally offered by the party, otherwise it can be excluded and rejected. That's the case of heirs of Pasag versus spouses Parocha. Okay. Itong reservation ang pinaka-importante. Okay. Di ba sa ngayon, pag when we go to court, sometimes we just say, Your Honor, may we reserve the presentation of additional documentary or testimonial evidence should, as circumstances may warrant. Okay. Okay na yun. May reservation ka. Pero ngayon, ang reservation hindi na pwedeng ganon. Why? Because it's very clear here under this section, reservation of evidence is now expressly allowed subject to the following conditions. Number one, for testimonial evidence by giving the name or position and the nature of the testimony and the proposed witnesses. For documentary evidence and other object evidence by giving a particular description of the evidence. No reservation shall be allowed if not made in the manner described. Hindi na yung catch-all. No? Ngayon, kailangan mong sabihin sa korte kung ano yung ebidensyang nire-reserve mo. Okay? Kung hindi mo sabihin at i-describe yan, hindi ka napapayagan. Okay. Consequences of the failure of without just cause to appear during the pretrial despite due notice, the failure of the plaintiff and counsel to appear without valid cause shall cause the dismissal of the action. The dismissal shall be with prejudice unless otherwise ordered by the court, Section 5. Now, if it's on the part of the defendant and counsel, the defendant will not be declared in default. Bakit? May naman siyang answer. But, okay, he will suffer the consequences of default, such as what? The plaintiff now may be allowed to present his or her evidence ex parte. And now, and this time, it's very clear when the plaintiff must present his evidence ex parte, within 10 calendar days from the termination of the pretrial, so that the court now will render judgment on the basis of the evidence presented. If you do not also appear during the pretrial, defendant, you do not plaintiff, you do not appear, shall result in a waiver of any objections to the faithfulness of the reproduction mark or their genuineness and due execution. Hindi ka umapir sa pre-trial. Okay? Yung plaintiff cannot question it anymore. Okay? The failure without just cause of a party and or counsel to bring the evidence required shall be deemed a waiver of the presentation of such evidence. Unless, of course, I think you make a reservation. Okay. Now, okay. Now let's go to notice of pretrial. Okay, the notice of pretrial shall include the dates respectively set for, and this is now the amendment. Kasama na ang schedule ng pretrial, ang court annex mediation at saka yung JDR. Okay. And which means ngayon sa rule 18, it's very clear that JDR and mediation are part of the proceedings or the pretrial conference. Okay. Now, non-appearance in any of the foregoing settings, you don't appear during JDR, you don't appear during court annex mediation, shall be deemed as non-appearance at pretrial and shall merit the same sanctions as Section 5, which is good because some people, they do not attend mediation, okay? Kasi mediation lang. No. Ngayon, pwede kang ma-dismiss yung complaint mo. Pwedeng mag-evidence to be presented by the plaintiff. The defendant may be able to present his evidence ex parte against the plaintiff if plaintiff failed, okay, to appear during mediation or judicial dispute resolution. Okay? Now, the non-appearance of a party and counsel may only be excused for acts of God, force majeure, or duly substantiated physical inability, and that is Section 4. Okay. Once a representative appears, that representative must be fully authorized to appear during the pretrial, mediation, and the JDR. Okay. Now, let me just, okay, your pretrial brief, very important. Okay. It is mandatory and you still have to submit it at least 3 calendar days before the date of the pretrial conference. Okay. Now, in the pretrial brief, okay, you should include a concise statement of the case and the reliefs prayed for, summary of the admitted facts and the proposed stipulations, the main factual and legal issues to be tried. Hindi lang issues, dapat yatiin mo, factual, legal. The propriety of referring factual issues to the commissioner, the documents or other object evidence to be marked stating the purpose thereof, the names of the witnesses and the summary of the respective testimonies, and a brief statement of points of law and citation of authorities. Okay. Kung mapapansin ho nyo dyan, merong hindi na isama dyan. Kung yung dun sa dating Rule 18, di ba nakalagay the availment of modes of discovery. Ibig sabihin ba hindi na encourage yan? The answer is no. Encourage pa rin yan. Because even if that specific provision was not carried over to the 2019 rules, Section 7H of Rule 18 of the 2019 rules specifically requires that the provision of AM number 03-1-09 pretrial guidelines must still be followed. At dyan sa AM number 03-1-09, very clear in 1.2, resort to modes of, you will be ordered by the court precisely to avail of the modes of discovery. At ang importante din dyan sa incorporation of that AM administrative matter, we still follow and the court can still require the parties to follow the one-day witness rule, okay, and the most important witness rule, okay? Now, okay, pre-trial order, okay. A pre-trial, okay, upon termination of the pre-trial, the court shall issue an order within 10 calendar days which shall recite in detail the matters taken up. Okay, so ayun ang nalagay, A, okay, but may panibagong nilagay dito yung the case, it should be included in the pre-trial order. The case flow chart to be determined by the court which shall contain the different stages of the proceedings up to the promulgation of the decision and the use of time frames for each stage in setting the trial dates. You know what is so nice about this, okay? Para siyang game plan eh. Pero ang gagawa niyan yung court. Okay? And that will be our guide. Okay? Now, as I said, no? Also in the pre-trial order, it should state that there should be a statement that the one-day examination of witness rule and the most important witness rule shall be strictly followed. Okay? Now, a statement, and this is important, okay? A statement that the court shall render judgment on the pleadings or summary judgment as the case may be. Anong ibig sabihin yan? The court can decide to submit the case on the basis of judgment on the pleadings or summary judgment motu proprio. The direct testimony of the witness for the plaintiff shall be in the form of JA after the identification of such affidavits and cross-examination. Postponement of presentation of the parties' witnesses at the scheduled date is prohibited except if it's based on acts of God, force majeure, or duly substantiated physical inability of the witness to appear and testify. Ilang beses na natin itong narinig at maririnig niyo pa yung pagdating natin sa Rule 30. Okay? It only goes to show the importance, the premium these rules have given to the principle na talaga dapat mabilis na ang proseso sa korte. No? Hindi ka pwede basta-basta mag-postpone. Okay. Now, let me just focus on this particular provision, okay, also in pre-trial conference. Section, give me 1 minute please, Section 8. After pre-trial and after issues are joined, the court shall refer the parties for mandatory court annex mediation. The period for court annex mediation shall not exceed 30 calendar days without further extension. Okay. Ngayon, pag hindi na settle dyan sa court annex mediation, pwede ka bang mag-invoke? Please, Your Honor, pwede ba kaming mag-JDR? Okay. And this is now the rule in JDR, pursuant to Section 9. Only if the judge of the court to which the case was originally raffled is convinced that settlement is still possible. So it is the call of the judge. If the judge thinks that, oh, may possibility pa to, o kaya talagang mabuti mag-settle to dahil magkakapatid ito, okay, then it will be referred to JDR. But unlike the current practice, no, if the case is to be referred to JDR, the case may be referred to another court for JDR. It is not the court that is to which the case was originally raffled. It is to another court. The judicial dispute resolution shall be conducted within a non-extendable period of 15 calendar days only. Not 30 days, but 15 calendar days from notice of failure of the court annexed mediation. If JDR trial before, okay, if the JDR fails, the case will go back to the original court and trial will proceed. Okay, now, Section 10, okay, Section 10. This is new, okay. Should there be no controverted facts or no more genuine issue as to any material fact or an absence of any issue, or should the answer fail to tender an issue, the court shall, without prejudice to a party moving for judgment on the pleadings under Rule 34 and Rule 35, motu proprio, include in the pre-trial order that the case shall be submitted for summary judgment or judgment on the pleadings without need of position papers or memoranda. In such case, judgment shall be rendered within 90 calendar days from termination of the pre-trial. The order of the court to submit the case for judgment pursuant to this rule shall not be subject to appeal or certiorari. Anong ibig sabihin yan? If based on the stipulation, based on the papers already before the court, okay, sinabi ng court, wala nang issue to, no issue at all. I now decide that I will submit this for judgment on the pleadings. Or if the ostensible issues were unmasked to its very core, showing that the issues are what? Sham, fictitious, not even genuine at all, okay? Then the court now will decide, I will submit this case for decision based on summary judgment. That order submitting the case for judgment on the pleading, that order submitting the case for summary judgment will be included in the pre-trial order. Now, thus, the order of the court submitting it for summary judgment, the order of the court submitting it for summary judgment or judgment of the pleadings, hindi pa yun yung judgment. Okay? Technically, interlocutory order yon. And that's the reason why the court, okay, the order of the court to submit the case for judgment of the pleadings, summary judgment, it cannot be subject to appeal or even certiorari. Okay? Ito yung innovative dito ngayon, innovation rather, na the court during the pre-trial stage, based dun sa nakita niya, can make that decision now na I would submit this, okay, for judgment on the pleadings on motion for summary judge on the basis of summary judgment. Yung order ng court na yun, as I said, not subject to appeal kasi wala pa yung judgment eh, di ba? Or certiorari, hindi mo yan ma-certiorari. Okay. So we're done with Rule 18. Okay, for lack of material time, I will not go over the provisions, as I said, which were not changed. Okay? Like for example, rule on intervention, walang pagbabago dyan. Wala. Okay? Now, sa rule 19, ganun din sa rule 20, walang pagbabago. Okay? Subpoena. Okay, ang pinakabago lang sa subpoena actually is under section, wait, there's one eh. Section 6, where you are now required, okay, to tender the cost for court attendance and the production of documents and materials subject of the subpoena. Okay? And then we go now to computation. Walang pagbabago dyan, but I just have to say this sa computation. Okay. The court clarified the provision, yung sinasabi, okay, di ba if your deadline falls on a Monday, if your deadline falls on a Sunday, technically you can submit it on a Monday, okay? Pero paano pag humingi ka ng extension of time? Kunwari, ang ipa-file mo i-answer. Humingi ka ng motion for extension of time to file an answer. Where will you reckon the additional 30-day period? Will you reckon it on the Saturday or on the Monday? Okay, or Saturday or on Monday? Okay. Anong sabi ng Supreme Court? And this is the case of Luz versus National Amnesty Commission. Okay. Okay, it says, the extension granted by the court, okay, this one's a Court of Appeals case, now, should be tacked to the original period, which is Saturday, and commences immediately after the expiration of said period. And the resolution AM number 00-14-SC, the CA in that particular case has no discretion to reckon the commencement of the extension it granted from a date later than the expiration of period, regardless of the fact that the said due date is Saturday, Sunday, or legal holiday. Okay? So dapat i-reckon mo yon sa Sabado, hindi doon sa Monday. Okay? That's the case of Luz versus National Amnesty Commission. Okay. Depositions 23 to 29, walang masyadong pagbabago dyan, except in 2 sections. Section 1, Rule 23. Di ba yung deposition pending action when may be taken? Di ba yan, ang rule ngayon, okay, is depende kung leave of court or as a matter of right kung kailan ka magte-take ng depositions. Under Section 1, basta deposition pending action, regardless of whether you take it before an answer has been filed or after an answer has been filed, deposition can be obtained. You can do your deposition upon ex parte motion of a court. All you have to do is file an ex parte motion of the court. And because this is a non-litigious motion, then the court, okay, will resolve it within 5 days. Okay. The next, consistent with that also, the other provision that was amended is the provision on interrogatories. Let me just get interrogatories, okay? Section, okay, let me get a specific section, please, okay? Section, Rule 25, Section 1. Section 20, Rule 25, Section 1, when you want to avail of the mode of discovery, particularly interrogatories to parties, you only have to file an ex parte motion, okay, upon the filing of an ex parte motion. Those are the only changes when it comes to modes of discovery. Okay. So let me now proceed to trial. Again, okay, ito talaga yung again, masyadong madaming pagbabago. Okay. Consistent with the underlying premises of the amendments, the schedule of trial is required to be continuously conducted and the period strictly observed. Thus, the party who caused the postponement is warned that the presentation of its evidence must still be terminated on the remaining dates previously agreed upon. Okay. Okay. Let's see Section 1. The party shall strictly observe the scheduled hearings as agreed upon and set forth in the pretrial order. So the pretrial order must now contain the schedule, okay, of the trial proper. The schedule of the trial dates for both plaintiff and defendant shall be continuous and within the following periods, okay. The initial presentation of plaintiff's evidence shall not be set later than 30 calendar days after the termination of the pretrial conference. Plaintiff shall be allowed to present its evidence within a period of 3 months, okay, or 90 calendar days, which shall include the date of the judicial dispute resolution. Eh kung nag-JDR ka, maximum of 15 days. Theoretically, hindi 90 days yung iyong presentation kasi nakasama doon yung JDR. Theoretically, that's 90 minus 15. Okay, 75, di ba? Dapat tama yun. Okay. Now, if the initial presentation of defendant's evidence shall be set not later naman than 30 calendar days after the court's ruling on plaintiff's formal offer of evidence, the defendant shall be allowed to present its evidence within a period of 3 months or 90 calendar days. So 90-90. Pero pagdating sa plaintiff, naaawas doon o binabawasan yung 15 days for JDR. Okay. Now, the period for the presentation of evidence on the third-party claim, counterclaim, or cross-claim shall be determined by the court, the total of which shall not exceed 90 calendar days. If deemed necessary, the court shall set the presentation of parties' respective rebuttal evidence, which shall be completed within a period of 30 days. The trial dates may be shortened depending on the number of witnesses to be presented. Remember, the most important witness rule will still have to be followed, no? Provided that the presentation of evidence of all parties shall be terminated within a period of 10 months or 300 calendar days. If there are no third party claim, counterclaim, cross-claim, the presentation of evidence shall be terminated within a period of 6 months, okay, or 180 calendar days. The court shall decide and shall serve copies of its decision to the parties within a period not exceeding 90 calendar days from the submission of the court for resolution with or without memoranda. Okay. Now, in Section 2, okay, in Section 2, and all I want to focus on Section 2 is the party who caused the postponement is warned that the presentation of evidence must be still terminated on the remaining dates previously agreed upon if your motion for postponement has been granted. Okay? Now, Section 4, in dates lang, no? Court should start at 8:30 in the morning, 2 o'clock in the afternoon, and then, of course, all courts shall ensure the posting of their court calendars outside their courtrooms at least 1 day before the scheduled hearing. Okay. Okay. Now, let me proceed please to consolidation, walang pagbabago dyan. Okay. Okay, and same with trial by commissioners, no change. No? I would like to focus our discussion on actually, okay, before I proceed further, Section 33. So it's going to be 33, 34, 35. And I have 30 minutes. I see that it's only 32 minutes. Okay, and I'll be able to finish this. Okay, demurrer to evidence. Okay. After the plaintiff has completed the presentation of his or his or her evidence, the defendant may move for the dismissal on the ground that upon the facts and the law, the plaintiff has shown no right of relief. If his or her motion is denied, he or she shall have the right to present evidence. If the motion is granted, but on appeal the order of dismissal is reversed, he or she shall be deemed to have waived the right to present evidence. Okay. What is the difference between the affirmative defense, that yung affirmative defense is failure of the complaint to state a cause of action, and a motion to dismiss on the basis of lack of cause of action? An affirmative defense, which is failure of the complaint to state a cause of action, is governed by Section 12, Rule 8 of the 2019 rules. Whereas a motion to dismiss based on lack of cause of action is governed by Rule 33, the mirror to evidence. Now, that affirmative defense of failure to state a cause of action can be determined only from the allegations in the initiatory pleading and not from evidentiary or other matters alluded. Now, if it's the mirror to evidence, it can be determined after the plaintiff has rested his case and can be resolved only on the basis of the evidence presented and admitted by the court in support of the claim. Okay. Now, so in other words, when you speak of failure to state a cause of action, it is based on a preliminary objection which can be ventilated before the beginning of the trial. Whereas the mirror to evidence is in the nature of what? The mirror to evidence on the ground of insufficiency of evidence and can only be presented only after the plaintiff has rested his case. And that is based on the case of Manila Banking Corp versus University of Baguio. Okay. So the mirror to evidence authorizes a judgment on the merits without the defendant, okay, having to submit evidence on his part as he would ordinarily have to do it if plaintiff's evidence shows that he is not entitled to the relief sought. The mirror, therefore, is an aid or instrument for expeditious termination of an action, similar to a motion to dismiss, which the court may grant or deny. And that is the case of Dandoy versus Court of Appeals. Okay. Now, notice that in Section 2, may bagong Section 2 okay? And the mirror to evidence shall be subject to the provision of Rule 15. Ano yun? Motion. Because this is a litigated motion, as I said, you don't put any more notice of hearing. Wala ng 3-day notice rule. I-serve mo, i-file mo, and then the court, in the exercise of its discretion, if it's necessary to conduct a hearing, the court will now be the one that will set the case for hearing. And because it's a motion, it will be set on a Friday. All you have to do is wait for the order informing you when the hearing, okay, on the motion will be conducted. If at all the judge decides to set it for hearing. Okay. The order denying the demurrer to evidence shall not be subject to appeal or prohibition or petition for certiorari, prohibition, or mandamus before judgment. Okay. The order denying the demurrer shall not be subject to appeal or petition for certiorari, prohibition, or mandamus before judgment. So, anong gagawin mo dyan? Ang remedy mo dyan, mag-trial at intayin mo yung judgment. At pag talo ka pa rin, yan, mag-file ka ng appeal. Diba? Now, paano kung grant? Kung grant, that's a final order. Okay, kasi ibig sabihin nun, dismiss, diba? O kung grant naman siya, anong mangyayari? Because that's a final order, it's concept of a judgment, then the remedy there is appeal. Okay, now, inapila mo na inappeal. Pagdating sa appeal, ni-reverse. Okay, ni-reverse ng Court of Appeals. Can the Court of Appeals now remand it to the lower court and direct the lower court to render judgment? No. In the case of Regio Wealth, anong sabi ng Supreme Court? In the case of Regio Wealth, the Court of Appeals, okay, the Court of Appeals must render judgment. In other words, okay, now, the rule now imposes the condition by the same token that if his demurrer is granted by the trial court and the order of dismissal is reversed on appeal, the movant loses his right to present evidence in his behalf, and he shall have been deemed to have elected to stand on the insufficiency of plaintiff's case and evidence. In such event, the appellate court, which reverses the order of dismissal, shall proceed to render judgment on the merits on the basis of plaintiff's evidence. Okay, and that's the case of Radio Wealth Finance versus Del Rosario. Okay, and then finally, Rule 34 and 35. Okay. Dito sa Rule 34, which is judgment on the pleadings. Di ba pag binasa mo yung complaint, binasa mo yung answer, wala talagang issue. Parang wala. Lahat admitted siya. Okay? So walang issue at all. So you file judgment on the pleadings. But please take note of Section 2. Action on motion for judgment on the pleadings. The court may motu proprio or on motion render judgment on the pleadings if it is apparent that the answer fails to tender an issue or otherwise admits the material allegations of the other party's pleadings. Otherwise, the motion shall be subject to the provision of Rule 15. Any action on the motion for judgment on the pleadings shall not be subject on appeal or petition for certiorari. Okay. Notice that consistent with Rule 18 pre-trial, the court motu proprio can decide to submit the case for judgment on the pleadings. Okay. On its own. Okay. Now, any action on the motion, for example, if the let's say the plaintiff or the defendant files a motion for judgment on the pleadings, if it's granted or denied, okay, kasi any the judgment on pleadings cannot be subject of appeal or petition for certiorari prohibition on mandamus. Which means the order granting the motion, hindi mo yung subject sa Rule 65, hintayin mo yung desisyon. Okay? At pag hintayin mo yung desisyon, lalabas yung desisyon, diyan ka ngayon mag-appeal. Okay? Rule 35, summary judgment. Ang summary judgment is what you call accelerated judgment. Okay? Binasa mo yung complaint, binasa mo yung answer. Ay mukhang may ostensible issue. Okay, parang may issue. But because you submitted now depositions, counter affidavits through a motion for summary judgment, no, that ostensible issue was parang yung kung tutuusin mo lang ostensible issue na yun, hindi pala issue. It's a sham. It's a mere sham. Okay, and therefore you now submit the motion for summary judgment. Okay, please take note that it is only during pre-trial, pursuant to Rule 18, that the court motu proprio can submit the case for judgment for summary judgment. If you read Section 35, walang nakalagay dito na motu proprio the court can submit the case for summary judgment. It is only during pre-trial that the court can motu proprio submit the case for judgment, for summary judgment. And why do I have to stress that? It would appear that if after pre-trial, okay, the parties can still submit a motion for summary judgment, pero upon motion of the party, hindi motu proprio. Kasi yung motu proprio decision to submit it for summary judgment can happen only on the part of the court during pre-trial. Okay. And the last topic which I would like to discuss, okay, is itong Section 4. Okay, again, similar to judgment on the pleadings. Any action of the court on the motion for summary judgment shall not be subject of appeal, petition for certiorari, prohibition, or mandamus. Other words, wait for the judgment at yun ang i-appeal mo if that is a final judgment. Okay. Notice, however, that not all resolutions, okay, on a motion for summary judgment is a final judgment or a final order or resolution. Because Section 4, okay, contemplates a situation that a partial summary judgment can be issued by the court. Kasi case not fully adjudicated on motion. Which means a careful reading of this section reveals that a partial summary judgment was never intended to be considered a final judgment as it does not put an end to an action. Why? Because if you read, okay, this particular phrase in the middle, including the extent to which the amount of damages or other relief is not in controversy, and direct such other or such further proceedings in the action as are deemed just. Anong ibig sabihin nun? Magkakaroon pa ng hearing dun sa mga issues na hindi na-resolve ng motion for partial judgment. At anong magiging remedy? Okay, if there is only a motion, there is only only a portion of the issues, let's say a part of the issues were submitted for partial summary judgment. According to the case of Philippine Business Bank versus Chua, what the rule contemplates is that appeal from partial summary judgment shall be taken together with the judgment that may be rendered in the entire case, after a trial is conducted on the material facts on which a substantial controversy exists. This is on the assumption that the partial summary judgment was validly rendered. Okay. We have now discussed the highlights, okay, the important provisions that were introduced by the 2019 amendments to the 1997 rules on civil procedure. I would like lang to answer some of the questions that were raised, okay? And I have to refer now to the questions that were posted last time, okay? Okay, just give me a minute so that I can read them, okay? Okay. Just 1 minute, please. Okay. 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 This was from last Monday. Okay. Within what time should defendant, foreign private juridical entity, file its answer if summons is served upon it through the modes enumerated under the second paragraph of Section 14, Rule 14? If it was served on a resident agent, or if it was served, let's say, on the officers who are founded in the Philippines, then it should be the regular, which is 30 days. But if it was served, let's say, through, let's say, what you call this, let's say, a government agency over which it exercises supervision over that foreign juridical entity, then it should be what? 60 days. Same then pag publication, 60 days. Okay, unless of course a different period was stated in the order of the court. Okay. Section 6B, Rule 7 of the amended rules expressly requires the judicial affidavits of witnesses should be attached to the complaint or answer. Is that required also with respect to the documentary evidence other than those characterized as actionable documents? Or is it enough that the same be just stated in the pleading pursuant to the opening sentence of Section 6? I think consistent with the philosophy behind the rules, no? You have to state everything already so that there will be no surprises. What is the time to plead in a case a motion to dismiss is denied? You have the remaining period na lang, wala na yung remaining period, yung in no case not less than 5 days, wala na yon, because precisely Rule 16 was already deleted. No? Within what time should the defendant foreign, I think I've answered this already, who will accredit the couriers, SC or RTC? I believe it's going to be the SC for purposes of uniformity. Okay. On private couriers, isn't this the reckoning of date of filing? If the pleading or any other submission was filed to an accredited courier, the filing shall be proven by the affidavit of service of the person who brought the pleading or other document to the service provider together with the courier's note, because this is proof of service, okay? Is there a need for filing of actual hard copy in court if service is done via electronic means? No, it is not a requirement. That is not a requirement stated under the rules. How are filing fees computed, paid if filed electronically? We just have to, the filing fee will not, the amount of the filing fee will not be changed. It will not depend on how you're going to file it, because it will still be based on Rule 141. Okay. I've already discussed, wait, huh? Okay. Now let me just double check if there are other questions in Facebook wait, I really do not know how to do this. Just give me 1 minute, okay? Okay. So, wait lang ha. Sandali lang. Okay. How do I go about this? Okay. Just 1 minute, please, and let me go to Facebook. I do not know. Wait. How do I go to Facebook now? Okay. Okay, let me see. Okay. Okay. There's a question. Will the revised rules apply to cases already pending before the court? We know that when it comes to rules of procedure can be applied retroactively on cases still pending. Okay, so I guess, and this is just a guess, no. Of course, yes, it can, especially if the cases have yet to reach the pre-trial stage, yung pasimula pa lang. Pero kung kunwari presentation of evidence, kung ano na lang yung pertinent provision na applicable, pwede. Oo. Okay. Okay, I have taken so much of your time, and I hope that through this we were able to alleviate your concerns. And I really hope and pray that that through this project initiated by our president, Dean Mari Anenias, we were able to, at the very least, assist you. And I said, alleviate your concerns. I hope that this pandemic will soon be over and we'll be able to go back and enjoy our normal lives. But in the meantime, stay safe by the grace of God, and I hope to see you soon. And I wish you all the best this coming days. Maraming salamat po. Incidentally, before I forget, okay, there are other lectures that will be presented or aired. Okay, I think the next lecture series, the next lecturer, I think, will be our vice president, the vice president of PALS, and that is Dean JP, okay, Villasor, and he will be talking about the constitutional framework in times of COVID, no? And then after that, I think Dean Ada will go back again to finish her labor lecture, and then the former chairman and president Dean Milo Medina will also talk about the amendments to the corporation code. I hope that you will be able to join us, because I'm very sure we will learn a lot from my distinguished colleagues. Again, thank you very much and enjoy the rest of the day. Thank you.